ओके, ओके। आप सीता के साथ हो?
म्यूट अंकल। Hello. Good morning, dear participants, respected judges, and everyone who's viewing. Thank you so much for joining in. We will be beginning the session within the next 10 minutes.
Uh, Hello. Hi, am I audible?
Sir, yes, you're audible.
Yes,
Great.
sir.
Okay. Should I pause my feed right now?
No, sir, we can begin right now.
Okay.
Good morning, respected judges and dear participants. Welcome to the 11th RCL National Moot Court Competition 2023. Before we begin with the event, I'd like to share some rules and regulations. Number one, there shall be elimination rounds and only 4 teams shall qualify to the semi-finals, which we are doing right now, according to the aggregate scores of both preliminary rounds. The 4 teams that have qualified are already in the preliminary rounds, and we have 2 teams with us right now. In this round, 2 teams shall have two pre-appointed speakers and each round, and they shall remain same in each round. Each team will get a total of 25 minutes, including their time for rebuttal and rebuttal. Any extension of time shall be subject to the discretion of the judges. The division of time between the speaker is the discretion of the team members, subject to a minimum of 10 minutes for one speaker, including rebuttal and rebuttal. The speakers are requested to tell their time division before the commencement of the round to the respective judges and the readers. I request all teams to kindly tell me their division of time.
Team code 13, both the speakers will speak for 10 minutes each, and the remaining time will be for rebuttal.
TC 26, the first speaker would speak for 11 minutes, and the second speaker would speak for 14 minutes, including the arguments as well as rebuttals.
Noted. I will now request the petitioners to begin with their arguments.
Yeah, the bailiff may please keep us apprised of the time distribution among speakers.
Yes.
Yes, sir. So the team code 13 has requested that they be given 10 minutes per speaker plus the remaining time for rebuttal. Team codes 26 have requested 11 minutes for speaker 1 and 14 minutes for speaker 2, including rebuttal time. I will be notifying everyone when there are 5 minutes left, when there are 2 minutes left, 30 seconds left, and when the time is up, I will also be reporting it.
So we are starting with TC 13 first.
Yes, sir.
TC 13.
So TC 13 is the respondent.
Okay.
Apologies, sir. We will be beginning with TC 26.
TC 26. All right. So we can have first speaker, I guess.
Yes, sir. Greetings to all. The council seeks permission to approach the virtual dais.
You have all the permissions, whatever is needed. So you may proceed with the issues involved straight away. I think my learned judge, co-judge, would be fine with that if we can skip the fact recital, basically.
Yes.
Yes, let's come to the issues basically straight away.
So what
Much
issues are you
obliged.
addressing first, counsel?
Today, the first issue to be dealt with is whether the removal of the post by SMG violates the freedom of expression of Ms. Priya Khanna. It is humbly submitted before the Supreme Court of Bharat that the removal of the post by SMG.
No, what I want you to do is you've come to the Supreme Court. So I'll want you to address first and foremost on maintainability. So what jurisdiction have you invoked, and why should this court exercise this jurisdiction?
Indeed, Your Lordship. So the jurisdiction invoked is the writ of mandamus under Article 32 of the Constitution of Bharat, which was about to be dealt in the first issue itself. It is stated that the Article 32 of the Constitution of Bharat provides for the remedies which are available when the infringement of the fundamental right takes place.
So
There are
you essentially prayed for a writ of mandamus under Article 32, if we
yes, sir.
understood you correctly. All
Mm.
right. Now, what are the basic principles for the exercise of a jurisdiction for granting a writ of mandamus, and how do those get fulfilled? I mean, why should we grant a writ of mandamus in the first place?
The certain principles that have been brought forth in this petition is the present of a substantial question of law. The substantial question of law is whether the fundamental rights stated in Article 19(1)(a) and 21 would be applicable on a social media platform, which is also a private entity, that is the social media giant. Also, the bar of alternative relief would not be applicable because the very fact that
Counsel, are you seeking, what you are trying to do is you want a question of law, which is a substantial question of law, to be determined by us. Now, you specifically prayed for a writ of mandamus, as you've just informed. Now, how and in what manner can a writ of mandamus be granted in a case where there is apparently no clear position of law and there's no public duty as such, which is apparently vested in the other side? In fact, if anything, so I think the respondent social media giant must be a private company which is
Indeed, Your
incorporated
Lordship.
under foreign laws. So how is a writ of mandamus maintainable against it? That's the question.
And
Indeed, Your
adding,
Lordship.
excuse me, just adding to that only. Equally, a High Court would have a jurisdiction under Article 2 to 6 also. Why didn't you approach the High Court, but why are coming to straight away to the Honorable Supreme Court, as we can say? Because the writ of mandamus, Honorable High Court has also all powers. So add to that also.
Indeed, Your Lordship. Answering the question as to how a writ of mandamus is applicable when there is already an existing substantial question of law, it can be stated that through our petition, we make it apparently clear that there is a public duty vested in the social media giant. Plus, the writ of mandamus is applied in the situations where a direction is issued to the state for doing certain acts or for preventing certain of their orders. In this particular case, we want the SMG to curb their practice of correcting the tailored contents, for collecting the personal data for providing the tailored contents. And
Counsel,
moving
against
ahead,
whom are you seeking this writ of mandamus?
it is against the social media giant, the private entity.
Is it a public authority?
Sir, recently the courts of law have applied the doctrine of horizontal application of fundamental rights. It has also been stated in the case of Kaushal Kishore versus State of UP, where they stated that an entity, irrespective of whether it is a state or a non-state entity, that is, whether it is a state or a private entity, they are supposed to follow the fundamental rights
Can
stated
you
in Article 19 and
can you
21.
open this judgment and let us go through the relevant provision?
Yes, please
please?
let us go
And
through the relevant.
citation also. Citation also.
Yes, sir. Could you give me just 2 minutes?
Yes, please. Citation of the judgment.
I think your researcher can do this in the meanwhile, and you can continue addressing oral arguments on this very issue.
Yes,
Uh,
researcher, you may take out the judgment right now and assist us with this.
Indeed, Your Lordship, I just wanted to clarify that the researcher is I myself. So I would just present it on the screen, no issues.
All right. So
Mm.
we'll take out this 1 minute of yours from your. We won't be spending on your time basically. Just take it
Okay, sir.
out.
So is it visible, my screen?
No, not yes.
Now it is. Yeah.
Yes. So can
So
you
this
tell
is
the citation basically?
Yes, sure, sir. The 17th one.
Okay, this is 2023.
Counsel, can you read the relevant few sentences from that judgment and also show us? This is your interpretation of the judgment. That may or may not be the case.
I duly apologize, sir. I do not have the judgment of the case readily available with.
All right. Now, counsel, who are the respondents in the present case that you filed here before us?
The social media giant, sir.
So that's it.
Yes.
So you did not feel the need that anybody else, given that it's a substantial question of law, as you put it, you did not feel the need to implead anybody else as a party who could have come and assisted us in determining this issue?
Sorry, sir. The council could not think about it.
All right.
All right, continue.
So, as per this particular judgment, there was a fundamental principle proposed that the horizontal application of fundamental right, that it is applicable on both state and non-state entities. Further, as to why the council has appeared before
No,
the
counsel,
Supreme Court.
just a minute. Even if fundamental rights are applicable on state, non-state entities, etc., what we've tried to ask you is, how is a writ of mandamus, how will it lie against a private party who is apparently a business incorporated in a country abroad, and there is no specific provision under which any public duty seems to be vested on them?
Indeed, Your Lordship, for answering the same, though it is stated that there is no particular public duty which is prima facie or per se can be assumed in this particular case, but the directive principles of state policies provide us that the state should take care of all the economic, social welfare of the individuals.
Are they
And
enforceable in a court of law?
Sorry,
Yes.
sir.
Can you enforce directive principles? Can you ask this court to pass a decree or so-called a writ of mandamus to enforce a particular directive principle which you are pleading? So, see, counsel, our concern is that, in our opinion, as of now, you are not eligible to come here seeking a relief against a private body. The expression you have used, horizontal effect of the fundamental rights, it's not enough for us right now because you have not been able to cite the judgment. What exactly does it say? So, even if, let's say, granted that we are allowing this writ petition at this stage, what enforcement of fundamental right are you seeking against this private entity per se? And within which parameters of law are they bound to observe the protection of your fundamental right?
Indeed, Your Lordship. So the fundamental right that we seek to establish is stated under Article 19(1)(a), which provides for the freedom of speech and expression. By removing the contents of Ms. Priya Khanna from the social media platform, they have violated the freedom of speech and expression provided to her. As far as how did we approach to the Supreme Court under the writ of Article 32, it can be stated that under Article 141 of the Supreme Court of Bharat, the laws of the Supreme Court are binding on all the lower courts. Therefore, it is the most
Counsel, how can you approach a court and rely on 141, saying that 141's law will bind all other courts, and therefore that is the solitary reason that you've invoked an Article 32 petition? So I think on the issue of maintainability, you're absolutely lacking. You've come to us in 32. So against a private party, apparently vested with no public duty, at least nothing has been pointed out to us. So what we would advise you is to not rely on general provisions. What you can do is you can skip to the second issue or whatever other issue that you're dealing with.
Indeed, Your Lordship. I would like to clarify that Article 141 or substantial question of law are not the sole reasons, and even the horizontal application of fundamental right are not the sole reasons for coming before the Court, in the case of Dr. Janet Jaipal versus SRM University, a private unaided institution was considered as a state because they were performing a public function that was providing education.
Yes.
So,
So, all right. Now that you've gone there and harped on the test of a public body, a private body performing public functions, could you point out to the evolution of case law on this issue of the Supreme Court? So, what are the important judgments of the Supreme Court on this issue?
I may provide another case, that is Uni Krishnan case. In that particular case,
Also, those are all education matters.
indeed, Your
So,
Lordship.
Krishnan, this college, unaided college matter, these are all educational law matters. So, anything else?
Also the Kamal Kaushal Kishore judgment. The thing is, what I am seeing right now, I happen to open the judgment. Thing is, this judgment itself was being the relief sought in that judgment was against the state of UP because there was registration of some FIRs there. So as far as we are not convinced about your invoking our jurisdiction straight away while impleading only a private entity as a party to the present case. So as far as the courtroom reader is concerned, she's showing us the time up board right now. But just sum up your argument. Second, what other issue was you dealing with? The other issue, just quickly wrap it up.
Indeed, Your Lordship. So the other issues that is to be dealt is whether the freedom of expression is violated by the SMG. So under the Chintamana Rao versus State of Madhya Pradesh case, it was held that any restriction on the freedom of speech of an individual should be reasonable. It should not be arbitrary and should not be in excessive nature as to the objective that is sought to be achieved. In our particular case, the critique on the Gender Equality and Inclusion Act that is done by Ms. Priya Khanna in no way is violating any of the public order.
You voluntarily signed up on a private platform.
Yes.
Now, how do you claim a right of free speech on a platform which is purely private? And they have no obligation to adhere to any apparent rights that you are claiming here.
Let me bring it down further to you. For example, you and me join a WhatsApp group. We are one. I am the main host of the group. I restrict everyone to put anything on the group, but I put whatever I want to. Would you say that your right of fundamental expression and of speech has been restricted in the group? Because there is a voluntary admission into the group on your behalf, understanding the term that you won't be allowed to speak there. Would you say that I am violating your fundamental right?
Indeed, Your Lordship, I do understand the concern. However, I would like to plead that either for article violation of freedom of expression or for the violation of right to privacy, which was our subsequent second issue, it has been raised that there was a consent. What I would like to plead is that there was not an informed consent or a consent which is to be taken into consideration.
How do you distinguish?
Your answer is that your consent taken wasn't informed consent. You're saying that?
Indeed, Your Lordship.
How do you demonstrate that to us?
Indeed, Your Lordship. So in District Registrar Collector versus Canara Bank, it was held that
I'm now reverting back to the facts whereby you have to show us that while you logged in, made an account on the website, when you said I agree to the terms and condition of the website, that agreement to that website was uninformed by you. You have to tell me that how it is.
Indeed, Your Lordship. And for referring to the same issue, if Your Lordships permit me, I would want to refer to certain cases to prove my point.
Oh, we are asking a very factual question from your fact sheet. Basically, we are asking when you plead that it is an uninformed acceptance into the website, that means you were misled or were coerced in the terms of, well, if we use the general terms when a contract is void. So that entering into an agreement was either because of uninformed choices. Either you were a subject to fraud, you were misinformed, you were not given complete information what were you getting into. Can you demonstrate it from your facts that in fact it was an uninformed choice, or it's just
Yes.
a legal fluke you have just played?
Indeed, Your Lordship, I would like to say that it was not an informed consent because the
Yeah,
very
that is what we
reason,
asked. How?
Counsel, just
because
in one sentence, tell us what do you mean by informed consent and how does it apply here? Just in one or two sentences. That's it.
informed consent refers to a consent which is provided with all due notice or knowledge available to the petitioner
All
as
right.
to the
So
exact.
how was this consent not informed consent?
The privacy policy which was provided to the petitioner prior to signing into the website was provided in such a manner that there was no other option rather than accepting the same and then signing into the platform. So
Counsel,
it
did you raise
has,
any grievance at that point in time when you were actually signing this policy and making an account there?
no, Your Lordship,
Then are
the
you not
grievance
hit
was
by
not.
waiver and estoppel acquiescence?
Uh, Indeed, Your Lordship, I would like to state that there is not a waiver of fundamental right that could be done, as right to privacy is recognized under fundamental right, that is under Article 21 in Vasheshanath versus a CIT. It was held that fundamental right cannot be essentially waived. And further in Behram Khurshid Pesikaka versus State of Bombay, it was further reiterated that a fundamental right is not supposed to be waived. So here, a right to privacy cannot be waived.
Okay.
Further,
Okay,
the
Counsel, I
informed,
think your time is up. These were two issues you were dealing with, basically.
indeed, Your Lordship.
All right, now we can have the second speaker, I guess, for the sake of timing, basically. Though we are not convinced about the jurisdiction as yet.
Much obliged, Your Lordship.
Good morning, Your Lordships. With the Lordship's permission, I would like to approach
We
the
have granted
dais.
all permissions to you guys, so don't seek permission time and again, just go ahead.
Counsel, now that you've come to the Supreme Court for a substantial question of law, can you advise us as to how should a social media company frame its privacy policy so as to meet the touchstone of informed consent? So how should
That's
a
a very
social
valid
media
question.
policy be? And are there any sources that we can look at for our guidance?
It's a very valid question, Your Lordship. The first thing that the co-counsel would like to suggest would be a step-by-step verification instead of a huge page of a list of terms and conditions with a small button in the end that says, I accept all these conditions. Furthermore, the consent is simply informed, not informed due to the fact that to express my opinion over a public space, which is what social media has become, I have to accept a set of draconian community guidelines without which otherwise I would not even be able to talk about the issues that concern the nation or even me at a personal level, sir. This is my primary assertion to your question.
Counsel, are you sort of mingling up privacy and informed consent? Because that is the sense that I get from your answer.
Your Lordship, privacy and informed consent is basically two sides of the same coin. Without informed consent, privacy is essentially violated.
Okay. And
Because
can
we
you...
cannot claim, Your Lordship, we cannot claim the infringement of privacy unless we do provide an informed consent, which in the case of Ms. Priya Khanna was clearly absent.
All right. And since you've adverted to all of this, could you now cite some foreign jurisprudence that we could look at for determining this issue in a more holistic perspective and balancing all the imperatives?
With respect to privacy, sir?
Privacy, informed consent, community guidelines of social media, or companies, all of this.
But there's also
Let's sorry.
there's also a factor, you but again you have to plead this that it was in fact an uninformed consent. uh, it's hard to believe that you do not know the repercussions of a social media platform. Let us be very practical about the fact. As I quoted on the WhatsApp analogy just right now, I need not sign the WhatsApp or to be informed of the WhatsApp policy. But when I make a group and I make specify certain condition that certain posts would be deleted and the person would be disbarred. Now, in that scenario, you are very clear of the fact that I am violating your fundamental right. I am in fact violating why I shut you down or remove you from the group for posting something. But can you claim a relief against me saying, or an injunction from the court saying that you have wrongly removed from the group just because your fundamental right has been infringed?
Your Lordship, for this, I would like to argue that Miss Priya Khanna is merely a civilian, and we, the co-counsels, are representing her in this honorable court of law. Second of all, while yes, you are signing on to a social media platform with the knowledge that some of your data is being used by the social media platform. However, the mere fact that apparently SMG keeps arguing about their community guidelines being the reason for her post being taken down, while she was not given the simple remedy of the right to fair and equal justice and the right to be heard before such a post being taken down, is a simple indication to the fact that her fundamental right has been breached. And this fundamental right can be protected in a court of law because, as a citizen of the country of Bharat, she
Counsel,
does have all the rights to protect.
where do you infer that she has a right to be heard before the social media company takes down her post or takes any action against her? So, how do you infer natural justice here?
Natural justice is simply inferred from the fact that, as my co-counsel had stated, that SMG would come under the ambit of state. And to clarify this point, I would like to
Counsel,
cite
SMG
You
would
are
not come under the ambit of state.
you
Not
are
at
touching a
all.
very wrong nerve. Article 12. You are saying that you are covered under the scope of Article 12 now.
Your Lordship,
That's a very
since
we already conveyed our uh, message to you that on the jurisdiction aspect we are not convinced at all. You and further you have got yourself in trouble now by saying that you are now covering
In
yourself
fact,
Article 12 now.
your co-counsel's argument was slightly different. It was
Yes.
not that it's covered by state.
sir, with I am making this statement with full knowledge of the repercussions that it might have with the council, and so that is why I with the bench. But that is why I would like the honorable bench to refer to page number 15 of our memorial, which talks
Alright.
about Telefilms Ltd versus the Union of India, where it was held that though the BCCI is not a state as per Article 12 of the Constitution of India, it is subject to the writ jurisdiction of Article 226.
Counsel, how
And
do you read the tests laid down by the Constitution bench in Pradeep Kumar Biswas?
Yes.
Which test do you fulfill? In what manner?
Sir,
Let us
in
see
the
that.
simple in the simple manner that while disseminating information on its platform, by disseminating
Okay, what are
important
the
news,
tests laid down for an entity to be considered as state under Article 12?
there is a five-pronged test, sir, which was held in
Yes.
Pradeep Kumar Biswas versus
List one by one. Let's see.
whether the state mainly or chiefly contributes to the financial strength of the entity, whether there is deep
Yes.
and pervasive
Is
state
this
control.
fulfilled? Does the state of Bharat financially contribute to social media, giant? How is this fulfilled?
Sir, while I'm not going to rely on the Pradeep Kumar Biswas judgment,
We are relying
currently,
upon it's our judgment. You have quoted it. We are relying upon it.
Yes, sir. However, we are simply drawing a parallel between SMG, with in our case at hand, and the state, and we are not explicitly stating that SMG is a state as such. It does, however, exert a very pertinent state function of disseminating information. And
Council,
just
I
because
think
of this
You
fact,
are on a very sore footing. Let us
I
convey
think we can
you.
skip to the next issue. I
Yes,
just want
this
us
is a
to
very sore point.
go into more trouble on this.
Just owing to the shortage of time only, we are just blocking it ahead because it's a good argument to be made, but yet hard to be justified by you. Okay, come on to your rest of the issues which you're dealing with, basically.
much obliged, Your Lordships. So the third issue would be that it's humbly submitted before the Superior Court of Bharat that the taking down of Ms. Priya Khanna's post and enforcing its community guidelines infringe upon the principles of net neutrality and fair access to digital platforms. I'd like to argue the fact that the freedom of speech and expression includes not only the right to acquire information, but also to disseminate that information. And I believe it was decided in the Secretary of the Ministry of Information versus the Cricket Association of Bengal that political discourse is essential to the democracy, along with facilitating artistic and scholarly endeavors of all sorts. Not only that, the right to communicate also encompasses the right to communicate
Council, what do you
through
mean by
any media print.
what do you mean by net neutrality? Let
Net
us,
neutrality,
and is it a right? Is it a principle which is enforceable in law? How?
net neutrality is a principle that is commonly used in the domain of internet regulation and media law. Basically, net neutrality states that all data should be treated equally, regardless of who disseminates the data and regardless of what information the data relays.
And where do we get this principle from? Is there a statute? Is there a judgment that explains this?
Give
So,
me
what
one
is the
second, Your
source
Lordship.
of this definition and the principle?
It's a valid
source-
principle as you have quoted it. It's a interesting principle, in fact, but has it been judicially
Yes.
discussed? Is there a judicial precedent to it whereby this has been discussed to maybe a foreign judicial precedent, doesn't matter.
A foreign judicial precedent on the case would be NetChoice LLC versus Paxton, sir, which was held in the Texas jurisdiction of
Where
the
is
United
that in
States.
your memorial? Where is that in? Is it cited in your memorial?
NetChoice LLC, I believe, is cited in the memorial.
Where is
Which
it?
court? Where was this? When was this?
Yes.
Give me 1 second, Your Lordships. This is in page 26 of our memorial, citation number 54, NetChoice LLC versus Paxton, which was held in 2022.
Okay, this is a Texas House bill thing.
Yes, sir.
This is a House bill. Okay, let me read it from you. Instead, a policy that protects the consumer from social media censorship must be enacted. A brilliant example of his Texas, which prohibited large-scale social media from censoring speech based on the viewpoint of a speaker. This is not a case citation. This is not a judicial citation, no?
The Texas House bill itself is not a judicial citation. However, the NetChoice case, which I have
Counsel,
cited
what is the
immediately,
NetChoice case? In a nutshell, can you just explain in 2 sentences? And what did the US Supreme Court rule?
in the NetChoice case, basically a social media platform had contended in front of the Supreme Court of the United States that the Texas House bill would be unconstitutional because of the fact that media censorship would be unconstitutional by taking away the right of the platform to edit the information that goes on in the platform, as well as would be taking away its right to remain silent by forcing them to post all internet traffic and not regulate any of it. So the Supreme Court held that this argument that the social media platform was advancing was completely groundless. And the basis of their argument was that their fundamental right is apparently being breached merely by enforcing or the furtherance of public interest, which is what the First Amendment of the US stands for, enforcing public interest, essentially.
Okay, you can conclude up. I think your time is up. You can conclude in 1 minute. We are granting 1 minute for that now.
Thank you. I mean, much obliged, Your Lordships. The final argument that we have advanced is the removal and regulation of content moderation has been completely arbitrarily done by SMG. And this is merely because of the fact that algorithmic decision making is often opaque and their inner workings are hidden. This lack of transparency disempowers users and violates their right to understand the process behind decisions made by these algorithms. Greater transparency, as advocated by scholars, is essential. And in some jurisdictions, notably the General Data Protection Regulation, which has been passed in Europe, algorithms must provide explanations for their decisions, enhancing accountability. The opaqueness of algorithmic procedures reduces accountability and goes against the principles of transparency and due process when applied by
Just
social media
one
giants.
small question. Now that you've come before us, if a person's privacy or a right read their content is violated, can we simply make a guideline? Can we simply lay down a direction here in this court that person can avail an appropriate remedy available to them in law, such as a civil suit, such as something else? So would that be adequate redressal?
In the instant case, while a general application can be contended, however, in the instant case, a civil suit will not remedy the removal of the post by SMG.
Counsel, let me correct you here. Since right to privacy has been held to be a fundamental right now, as per the 7-judge judgment of the Honorable Supreme Court now. I think with its declaration, if you are alleging the violation of privacy as your sole ground, I think you can take an injunction from a trial court now. Why bothering this court? Because it has already been declared as a right, fundamental right now. Take an injunction, file a civil suit for injunction there.
The Honorable Bench in the Supreme Court of Bharat has been approached merely due to the fact that, first of all, considering the largeness and the behemoth influence that SMG exerts over the whole country, but also because of the fact that it's not only privacy that comes under question, but also the freedom of speech and expression, also the right to life and liberty under Article 21.
All right, make your prayer.
In front of this Honorable Court, Supreme Court of Bharat, we, the Counsel for the Petitioners, pray that firstly declare the removal of Ms. Priya Khanna's post that violates the constitutionally guaranteed freedom of expression. Secondly, direct the social media giant to cease data collection and content delivery practices that are an infringement of the right to privacy granted under Article 21 of the Constitution of Bharat, and pass any other order, direction, or relief that this Honorable Court may deem fit and appropriate in the interests of justice.
All right. Let us just give us a minute. Give us a half a minute. Just half a minute. I think we can then proceed with TC13 hereafter.
Much obliged, Your Lordships.
How we are ready? Okay, let's go ahead with TC13.
May it please this Honorable Court.
You
Your Lordship, the Council.
You are representing the SMG.
Yes, Your Lordship.
All right, go ahead. We have granted you all permissions. Come up with your issue. What issue do you have, and what in counter to your co-counsel? What do you have to say?
Yes, Your Lordship. Your Lordship, the Council appears on behalf of the respondent and would deal with issue number 1 and 3, and my co-counsel would deal with issue number 2 and 4.
What are your 1 and 3?
Yes, Your Lordship. Your Lordship, the issue number 1 deals with the question whether the removal of Ms. Priya Khanna, that is the petitioner's post, by the social media giant, that is the respondent, constitutes an infringement upon her freedom of expression. Your Lordship, before dealing with the issue of infringement of the right to freedom of speech and expression, the council would like to deal with the maintainability of the present petition, as rightly pointed out by your lordships.
We have already
No, we don't want
discussed.
to hear you on maintenance.
We don't want to hear on your, that is our domain right now. We have already countered your opposite counsel with that. Come over whether you taking down the post. Remember, you are a social media platform. You cannot claim the privacy as maybe in regard to some other website which does not have repercussions in terms of posting something there. You are basically disseminating the information and you have a larger social responsibility. You cannot claim immunity just by saying that we are a private entity. Your
Very well, your lordship.
kind of information reaches out to a lot of masses, which in a democracy like us has larger repercussions. So
Very well,
we
your
go
lordship.
ahead now, bearing these points.
Your lordship, the taking down of the social media post of the petitioner firstly was not only consented by the petitioner while agreeing to the community guidelines, but this taking down of the post was also well within the reasonable restrictions imposed on the one's fundamental right.
Council, what
Your
do you
lordship,
mean by
Article
community
19.
guidelines? What is
Yes.
a
Your
community
lordship,
guideline?
Your lordship, community guidelines are like a set of rules and regulations that the users need to first agree to while signing up, and then while posting anything on the social media platform, they
Who
need to
makes
adhere to
it?
that.
And what is the basis of these community guidelines? How do you decide what constitutes a community guideline?
Your lordship, the bases are obviously public morality and inclusivity and uh, anything that would not deem fit to be reaching out to a large number of masses, as your lordship rightly pointed out,
Council,
that we are working.
these are very general and vague statements
Yes.
you're making. We are asking who is the arbiter who lays down these guidelines. Of course, because since you remember one thing, what I have just stated initially is you have a larger responsibility when you're spreading the information at large. So your community guidelines, what is your source of community guidelines? Who is the arbiter behind writing those community guidelines? Who is responsible for that? Are you taking any cue from government policies? Are you taking any cue from any Supreme Court judgment for that matter? Or are you taking any cue from any general precautions which may have been provided in some government framework?
Your lordship, per se, there is no one judgment or one guideline that we refer to, but there are not multiple sources. But again, I would like to come back to that public morality and to create a healthy environment for all our users. And similarly, pertaining to any case law in India, your lordship, the judgment of Ajit Mohan versus State Legislative Assembly of NCT of Delhi, that judgment can be cited as a source.
Council citation, please citation with
Yes,
the
your lordship.
Yes.
Yes, your lordship. Just a minute, your lordship. Your lordship, Ajit Mohan versus NCT of Delhi citation is 2022 3 SCC 529. Your lordship, memorial page number 23.
So, in one sentence, what was held in this case?
Your lordship, this case particularly laid down the principle regarding the accountability of social media platforms and how they need to be more responsible to regulate their platforms.
Council, your guidelines, the community guidelines, would have been framed perhaps before this judgment came. Yes, in all likelihood.
Yes, yes.
When you first created these community guidelines, what did you take as a source? What did you look at, and how did you decide that these certain guidelines were to be your community guidelines? And are your do your community guidelines vary? For example, would your community guidelines, let's say in the United States, vary from your community guidelines applicable to India?
No, Your Lordship, the community guidelines remain uniform for everyone across the globe, all our users.
Okay, that's interesting.
So, if there are additional legal
Uh-huh.
requirements to be complied in India, those would not form a part of your community guidelines. Say something's not there in the US, but it's there in India. So that will not be a part of your community guidelines.
Your Lordship, as we know from the factual matrix that we do not have any offices in India or any servers in India. So whether or not we are obliged to follow the laws of the land, that is, I do not think that is necessary
So
to
if you
follow any laws that are there in India because we do not have any offices.
if you don't follow the laws of Bharat, should this court not shut you down in the first place?
Yes, this is a very dangerous argument you're making right now. Why should we allow to function even?
But Your Lordship, we do not have any main servers in Bharat.
If you are
Your Lordship, we do not have a main server in. Pardon me, Your Lordship. Your Lordship,
Yes.
sorry.
Just pause for a moment. I think my colleague has been disconnected for some reason.
Apologies, sir. So there was some mistake on our part. He will be returning to the room.
Yeah, I'm here. I think you
Yes.
Connected me to the other room.
Apologies, sir. There was some
All
No,
right.
it's okay. So, counsel, if you are stating that you are absolved of all legal implications arising on the state of Bharat just because you don't have an office in Bharat, I think we are going to shut you down. You have no right to work here.
Yes.
You have no right to earn revenue from the state of India as it is.
Can any business, even if he's incorporated anywhere, go to another country and blatantly take the position that he's not bound to comply with their laws?
Or he doesn't have an head office there or an office there.
Your Lordship, I would just like to change my answer a little bit. That we are bound by certain laws in India as well, of course, and such as like the Constitution of India, of course. That if we are infringing any of someone's rights or any of other laws of the land, then we are, of course, bound by those. However, our community guidelines are inclusive enough to, I feel that, to be uniform across the globe.
So that your learned colleague has cited judgment of what was that judgment?
The US Supreme Court.
Yes. How do you come out of that? Because that is a binding judgment. That is a binding judgment, and also whether this is a unique argument they have made of the net neutrality, which has found some judicial precedent somewhere. How would you decide a content which has to remain so-called neutral? It has to be treated as neutral content. Does your community guidance deal with that aspect or no?
Your Lordship, but firstly, I would just like to deal with the reasonable restriction that we have imposed. I would deal with the net neutrality aspect.
We are aware of reasonable restrictions. We are aware of reasonable restrictions. We know that reasonable restrictions has to be there. That is what Article 19 states. No doubt about it.
Okay. Your Lordship, the net neutrality aspect that was stated by my learned colleagues, Your Lordship, net neutrality mainly pertains to internet service providers. We are a social media platform, Your Lordship.
All right. Any document, any basis in law for you to assert that it only pertains to social media providers, it does not apply to social media providers?
Not particularly, Your Lordship, but the basic concept of net neutrality is that the different charges levied upon a person by internet service providers, that's the basic principle of net neutrality.
We don't know. Maybe that is the basic principle. Maybe it's not. So unless we have something to assist us with, we'll not be able to express any opinion. Now, moving further, what is the position of law in other jurisdictions? So, for example, the United States and the European Union, what is the position re-privacy and re-content, and what is the regulatory role that the state plays there? Please assist us.
Yeah.
Given that you already have head offices there and nothing here.
Your Lordship, there are GDPRs that the GDPRs and international conventions that we follow, as well as the Federal Communication Commission that is there in the United States. They play a very significant role in maintaining this net neutrality and this privacy and the freedom of speech and expression.
Sure, but I mean, what are the bedrock principles? Just outline a couple of them.
Your Lordship, with respect to privacy,
Yes.
Your Lordship, I would like to plead my ignorance on this. I do not know the exact principles.
Okay. Okay. Go ahead. Go ahead.
So I think he
Much
can
obliged, Your
take to
Lordship.
the next issue, whatever that is.
So,
Your Lordship, I would just like to deal with the issue of reasonable restriction, my issue number 1.
so reasonable restriction.
Council, leave accept.
What do you want to say for the petitioner? Just say that her content came within the reasonable restriction. Just demonstrate us to that. How?
Much obliged, Your Lordship. Your Lordship, the critique post that the petitioner had posted, that was taken down by us on the reasonable restrictions on the ground of Article 92 of the Constitution of Bharat, under the ingredients of public order and incitement of an offense, that is disaffection. Swami versus Union of India, the doctrine of proportionality was laid down to impose reasonable restrictions to one's
Council,
fundamental rights.
Factually speaking, she's just critiqued an act. How does this
Yes, sir.
interfere with public morality?
Yes.
Indecency? How does it amount to offense? How does it amount to disaffection, and what all you've contended?
Your Lordship, not public morality, but just that this post was not defaming the government, but rather it was leading to a feeling of disaffection amongst the general public. And as we know, because Your Lordship, now this entire post, this entire policy that was made by the government, this was made in order to advance the directive principle of state policy that is under Article 39 and 42, and also to empower women. So if there is any sort of negative posts about it, then that would just lead to a little bit of disaffection towards,
how would there be any constructive criticism, any engagement by civil society, anything at all, if at the slightest opportunity free speech is stifled?
Your Lordship, very well, Your Lordship. But then, as we know in the past in Bharat as well, certain minute disaffectionate posts have led to violent public disruptions, Your Lordship. And as a precautionary measure, we have taken this down. However,
but that is for the
sole ground of taking the post.
But that is for the state agencies to taken care of.
Yes. Did a state agency recommend in this case that the post should be taken
No,
down?
Your Lordship, but as a social media platform, we have the accountability and no, Your Lordship.
So,
but
how are you passing this value judgment on posts which apparently do not incite any violence, are not seditious, are not targeting any particular community, and are not hate speech in any form?
Your Lordship, it is just as a precautionary measure, that is to maintain the public order, and it also violates our community guidelines, that is that of inclusiveness. And it is due to these reasons and the reasons that are going to be mentioned ahead that we took down the following post. These are not the sole reasons, Your Lordship.
Okay, Council, one suggestion. It's not good enough for you to say it is community guidelines. You will have to justify as to how your community guidelines ought to be accepted by us, how those do not infringe any constitutional right of the petitioner. So it's not just good enough for you to assert, you'll have to seriously substantiate this. So,
much of this,
in a nutshell, another thing, do you think it's a good practice, and has it been done in, say, other jurisdictions, that we put a government regulator without whose approval you cannot take down any posts, whether for community guidelines or anything else.
So
Just
firstly, Your Lordship, I would like to deal with the community guidelines part of the argument. Your Lordship, the principle of community guidelines that was violated can an important principle is that of inclusivity. We as a social media platform, we are inclusive. That is, we have users of different of all the sections of the society on our platforms. And as this post would create certain disaffection and lead to the
No, I
infringement
think
of
you're
the.
grossly exclusive because you've stifled legitimate criticism.
Yes. And tomorrow, let us say, uh, you are a private conglomerate, basically. Your prime motive is to earn profits, not to serve the society as such. What we understand is tomorrow, some political party with vested interest pays you that take down these certain posts or these nature of posts criticizing us. Would you will be doing that?
No, Your
So
Lordship.
where does the accountability follows?
Your Lordship, the accountability follows because if someone pays us to do that, we would not be able to give a valid reasoning. However, in the present case, we have given the valid reasoning with respect to the community guidelines.
Okay, counsel, just sum up your argument. I think your
No,
co-counsel
I
is
think we can proceed to the next person. So,
okay. Okay. Let's go ahead with the next one. Okay, speaker number 2,
Much
please.
obliged, Your Lordship.
Come ahead.
Meet please, Honorable Court. I'll be dealing with issue number 2 and 4 on behalf of the respondents.
All right.
counsel, just answer this first.
Yes,
Should
sir.
we put a government appointed regulator, say a retired judge or a expert committee over and above you, which moderates the content before and then directs you to take it down?
Your Lordship, that suggestion can be well considered, but there are many issues regarding it. First of all, very statutory issues, and that might lead to the violation of the idea of that social media platforms can manage their own content, as has been laid out by YouTube LLC cases also in para number 20. And the issue here is not something which can be directly answered in this particular case, Your Lordship, but it may be considered that but the amount of social media platform or the posts themselves are such that directly moderating them would be by a committee itself can be a huge task.
No. The committee will not monitor each and every post, but
Yes, sir.
will monitor only any complaint that you receive, for example,
Yes,
and
sir.
before it's taken down, or even if it doesn't monitor at that stage, if the person who had posted that content makes a grievance about it, then the committee looks into it.
That can be done, Your Lordship. Even in the present case, we as a company themselves have a grievance redressal mechanism which has not been approached. The issue in the present case, Your Lordship, is that
See, the thing is, counsel, the so-called grievance mechanism is basically petitioner saying it's very partisan.
No, Your Lordship, they have not approached it. So contention that it is very partisan from the very first, this thing can.
So I think this is one thing we want a clarification from the TC26, that whether you have approached them with regard to their grievance redressal mechanism or not. We will answer that in rebuttal. Okay, you continue, please.
Yes, Your Lordship. As far as the issue of privacy is concerned, our contention is that first of all, there is no infringement of privacy because they have not claimed there is no substantial proof. And what the claims are is that the data is being collected. Of course, the data is being collected. There is no case on both the sides the data is not being collected. But the data which is being collected is in relation to the terms and conditions of the service to which the user has agreed upon in the very first instance. So,
Counsel, how do you come out of the argument that even if you took consent, that does not amount to an estoppel, given that this court has previously held privacy to be a fundamental right?
Yes, Your Lordship, it is true that it is a fundamental right and it directly cannot be considered as an estoppel. But even in this particular case, there is no direct violation. And regarding the case of waiver, as has been pointed out in Basheshwar Nag, my colleagues have pointed it out, it was only in relation to Article 14. That was very specifically mentioned in the case that they are not going into the question of waiver of other fundamental rights. And even in Puttaswamy judgment itself, the argument was still left open, and Justice Chandrachud has, in his opinion, even though it was not only an obiter dicta, it was pointed out that the idea of waiver has to be considered specifically in idea of privacy. Because if you're providing, the idea of privacy is that you will engage in a certain act and you may include and exclude somebody. If you're including somebody, then it will be shared. So that itself cannot be considered that we are not challenging that their fundamental rights do not exist. But in this particular case, the fundamental right has not been violated because they have agreed to it.
No, but they're saying it's an uninformed choice. What you do is you put up a 1,000-page PDF and just at the end of it, you are saying agree or disagree.
Your Lordship, in our
practically, it is very impossible for anyone to go through hundreds of pages, read every clause, and then say I agree, because that is actually very unreasonable to expect from a person.
Yes, Your Lordship, it is very unreasonable to direct them for, but we do not just ask for permission. As the colleague had pointed out that we ask for permission in the very first instance and then just click. Whenever you open a camera, you open any form of, it asks for your permission to allow or disallow it. And the second point is that if you want, you can prevent the company from taking it there. It's not like the contract once made cannot be broken down by the other party. And also, Your Lordship, the contention is that data is being collected, but the issue is why is it the problem is it is being misused, then only it will be a right to privacy issue, right? The misuse is not shown here, Your Lordship.
Counsel, where in law do you infer from that you have a right to collect somebody's data?
Your Lordship, in the Digital Personal Data Protection Act itself, it is said that the data fiduciary can collect the data provided by the consent of the data. Section 4 of the Digital Personal Data Protection Act, Your Lordship.
But
is it there in your memorial?
Yes, Your Lordship.
Page number?
Just a second, Your Lordship. It is on page number 18, Your Lordship, para 2.3.1.
Okay.
Counsel, at what stage do you seek the consent of a data principal to collect their data?
In the present case, we have, as soon as they enter into the app, we inform when they agree to the terms and conditions, we collect the data. So the intention behind is to create engagement and well-round user experience, Lordship.
And how do you utilize this data to create a better user experience? I mean, we want to understand as to what is the rationale of this.
So, Your Lordship, when particular interest, and it depends on the activity of the user on the app itself, how and why, like what interests them, and particularly if similar interests are done by other people, then we can provide
Counsel,
them with the same content.
Could you point out to any precautions that foreign regulators may have pointed out in the context of data collection by a social media platform?
There are many in European Union also, my Lordship. The GDPR guidelines have been laid down so as to like how it is to be collected, and it cannot go beyond reasonable this thing, and it should be limited to that particular application itself. And even in even in the United States, data collection is done in so far as only it is limited to the app, and it cannot be done for any thing which is not provided by the user. So,
okay, continue with your argument, please, which you had framed.
Yes, Your Lordship. So, similarly, as Section 4 also points out, and Section 7 also of the Digital Personal Data Protection Act says that, and for the specified purpose for which the data principal has voluntarily provided a personal data, the data fiduciary can use the personal data. So, even here, it is a voluntary, she has voluntarily provided it. There is no coerced consent, and as pointed out by the contended by the my colleagues that there is some coercion or it is a forced consent. That is not the case, Your Lordship, and therefore it cannot be stated that the right to privacy itself has been violated. And even in the case that right to privacy has been violated or it is a contention, there was a redressal mechanism. Section 13 of Digital Personal Data Protection Act also provides for a redressal mechanism, which the respondents themselves have. But here they have not approached it. Without even approaching it, they are just they just filed.
What is that grievance redressal mechanism? Who's in charge?
We as a company, like it is our own company's grievance
What does
redressal.
Section 13 say to you about that? The section you have just cited.
It says that, Your Lordship, a data principal shall have the right to readily available means of grievance redressal provided by a data fiduciary or concerned manager in respect of any act or omission of such data fiduciary or concerned manager regarding the performance of its obligation in relation to personal data of such data principal or the exercise of our rights under the provision of this act and the rules made thereunder. So,
Counsel.
yes, Your Lordship.
Yeah, please. Yeah, counsel. Is this an officer appointed by you, by your organization, who acts as the grievance redressal authority?
Yes, Your Lordship.
Why should the petitioner at all trust your officer for this when it is your organization which has taken down the content in the first place?
Why don't you appoint a neutral person? What does stop you
Yes.
from appointing a neutral person from being an officer of the this regulatory authority or the grievance redressal authority?
Your Lordship,
Ultimately, she is aggrieved by you. What do you
Yes.
do for redressal mechanism? You yourself appoint a person. How can we trust that that person would be very neutral in his approach when it comes to judging these issues?
yes, Your Lordship, but that is not the only grievance redressal mechanism. Even IT ethics code provides for Rule 3, Clause 2, which says that they can approach other grievance redressal mechanisms.
Come again, what have you cited?
The IT rules, the ethics code, Rule 3, Clause 2.
Are they mentioned in the memorial?
No, Your Lordship, they are not directly mentioned, but they are corresponding to the.
When were they enacted?
Your Lordship, they were, if I'm not wrong, enacted in 2021.
These have statutory force? These
Yes,
IT.
Yes, Your Lordship.
Now, merely because the petitioner did not go there, will it foreclose and should we shut her out from coming here?
Your Lordship, first,
That is your argument.
Major issue is what are the allegations? Particularly, they just stated that we are collecting data. There's no issue. We are not contending that we are not collecting data. But
No, I mean, the petitioners made a very fair argument about free speech stiflement.
Yes, Your Lordship.
How would your grievance redressal officer deal with that?
Yes, the grievance redressal officer will also deal with that. But the free.
Are your grievance redressal orders available in the public domain? And could you cite any one of them wherein the issue of privacy has been dealt?
The grievance redressal orders are directly not available, but if asked by the users, they can be provided with it.
And who does the grievance redressal officer report to, or the authority? Who does it report to? Does it report to, let's say, the Telecom Regulatory Authority of India or the Telecommunications Department of the central government?
No, Your Lordship.
So
it's by far the partisan mechanism. Again, we are dealing with, no?
It's almost secluded.
Yes.
Given that social media plays such an important role in today's time, even when there have been allegations, for example, of rigging the American elections.
Yes.
2016.
Yes.
So can we just allow you to get away by saying that, we have XYZ person sitting at so-and-so office and you can drop an email to him and then he will look at your complaint and decide?
We are not stating that just because they have not approached it, they can directly, the whole petition should be stifled. But in the present petition, they don't have a case regarding it also. What are the actual grounds they are challenging? That is the first issue. And even if they're challenging it, it is well within the reasonable restrictions of the company that we are doing it. So it's not
Okay,
like
okay, okay, counsel, you have this again, you are saying reasonable restriction. There are two posts, for example, I can understand that someone is inciting, giving an inciting speech to a general mass public, and that is posted on a social media platform. That we can per se, apparently, prima facie is itself very harmful for general peace of the society. We would say that will be a reasonable restriction.
Yes,
She has just only exercised the right of criticism, good or bad.
yes, Your Lordship.
Where does the line lie? Where does that, who will arbitrate that line?
Your Lordship.
An honest criticism, it may not suit you or it may not even suit the present regime. But she is protected by that fundamental right. Where does the reasonable restriction apply on her case? That is, we want to know. We are very clear about the reasonable restriction part. We are aware of that. But in this case, let us come to strict away. In this case, her post only dealt with the fair criticism.
Your Lordship, the arguments of the post or the contentions of the post are not even the question. They are stating that the post, just because we remove the post, their fundamental right has been violated.
So point is that when you removed it, you brought it under the ambit of reasonable restriction yourself.
Yes,
We
Your
are asking
Lordship.
you to justify whether that post would be covered under the term of reasonable restriction as such.
The term, it would be considered reasonable restriction, Your Lordship, because
Why?
because the criticism here was not just of any this thing. It was a government policy, and it was is the social media platform the right place to criticize such a post? That is should be the.
So why have you opened it? Now,
What is the
now,
objective?
what is your objective then?
No, the object, not in that sense, the objective, but Your Lordship, the contents of that particular post were not something which are community guidelines, which were based
What
on.
were the contents? Let's come to that. What were the contents? Let us read that.
Your
What
Lordship,
did she write?
the contents are not in question here.
Why not? It is because you are alleging the contents to be covered under the ambit of reasonable restrictions. You have used that word, counsel. I am saying allow us to be convinced of the fact that yes, the content actually came within the reasonable restriction. We will dismiss the case, we'll throw away the file. If it is not covering under the reasonable restriction, we are allowing this petition.
So the Lordship, the issue is reasonable restriction. We have to quote because first of all, they're contending that we are acting on behalf of the state.
You are acting on behalf of the state.
That is what their contention is. That is what they have come under Article 32. Our main contention is that the petition is not maintainable.
With regard to maintainability, we have right to admit it or not. We are not concerned. We are not actually taking care of your argument that they have they have invoked the right jurisdiction or not. That is not your concern anymore.
So
that is concern.
Yes.
Only thing which you can convince us of to dismiss the present petition is that her post, removal of her post was made under the reasonable restriction.
Yes, Your Lordship. In the present case, the particular legislation or the which was enacted was to promote and uplift women. In the what has happened by the criticism of this post, the petitioner goes against the government's policy, which was intended to further Article.
Which policy?
The gender inclusive and the act, Your Lordship.
But he is only criticizing the way it has been implemented. I am saying whatever the content was, it was a mere critique of something.
Yes.
As simple as that. Whatever of critique. And I think we are reasonably, I am saying it may not suit the present regime. She may be doing with her vested interest of being aligned to some political party, but she has a right to do that. You have to satisfy us that
Your Lordship, in the case of Kasturila Lakshmi Reddy versus State of Jammu and Kashmir, it was still that any action taken by the government with a view to give effect to any of the directive principles would qualify the reasonable restriction. In the present case also, that is the reasonable restriction. That is why we are applying it, because it is in furtherance of a DPSP.
Okay, you can sum up your argument, though we are not convinced that her case is covered under the reasonable restriction argument. Yet you can conclude that because your time is up as such.
So, Your Lordship, with regard to the first issue, the judgment of YouTube LLC, we as a platform ourselves have the right to moderate our own content. Secondly, there was no violation of her rights. With regard to the privacy, she has voluntarily consented, and her consent was not coerced in any manner, and therefore it cannot be considered that the right to privacy was violated. Regarding the third issue of net neutrality, we agree that net neutrality can be extended to the very
I think there's some trouble with the speaker.
That's okay. I think so. We can just start with quick rebuttals.
Rebuttal to the council. Just we want to know how do you come out of Section 4 of the Digital Act, which they have cited.
To come out of Section 4 of the Digital Act that they have cited, the Digital Data Protection Act has to be enforced as date, which it is not. It has simply been passed in both houses of the parliament and has received president's consent only in August 2023. It is
has
not an
become
act
a
that
law
has been
now.
enforced.
It has become a law.
Yes. So the larger issue will get taken care of.
Your Lordship, I did not understand your assertion. Can you repeat that?
So if it's been already passed by the parliament and it's received presidential assent, ultimately the larger issue that you've invoked our jurisdiction on will get taken care of. So in your case, maybe we can make a short direction under Article 142 at best, and that's the end of the matter. Nothing else is required. This matter can go.
Your Lordships, however, isn't the date of enforcement of the Act mandatory to even considering the Act as admissible in the state of law?
All right,
in this court of law.
We'll ask the central government as to when they propose to enforce it, and we'll make a short direction, and that's it. Okay. Anything? How do you come out of their argument regarding the grievance redressal mechanism that they have in one line?
One line. Your Lordship, may I extend that to 3 lines?
We pose this question to you. Whether you applied to their grievance redressal mechanism, whatever they have there on their website. Did you apply to that or no?
Your Lordship, first of all, the community guidelines of SMG, is it drafted in such a way that it finds an academic critique of a life-changing legislation a threat to its users? Second of all, Ms. Priya Khanna as a woman, is she not at the liberty to critique an act that she could be impacted by? Keeping that in mind, the grievance officer, which the Honorable Court pointed out to be as an agent of the company itself, how can such a grievance officer be entrusted with the task of upholding Ms. Khanna's fundamental rights?
Presumptuous so as to say that the grievance redressal authority will not act fairly and as it's required to do?
Sir, let us take, Your Lordship, let's take the example of sites such as X and Instagram, Your Lordship. These sites, before the posting of content, they have a disclaimer. They state that this content might violate the community guidelines, along with mentioning the section of the community guidelines that this content might violate. So if such has been done by the community guidelines of other similarly huge social media giants, then why can't SMG in the instant case do the same thing? Why did it resort to immediately removing the post?
Got it. I think you all can log out while me.
I think we'll just give a 2-minute opportunity to the other side.
Okay.
Your Lordship, I'm really sorry, but my co-counsel had just lost connection.
You can
I would just quickly like to say the prayers.
No, we don't need the prayers, just quick rebuttals.
We know the prayer. If there is any legal rebuttal, you can go ahead with that, please.
Your Lordship, with respect to the rebuttals, I would only like to point out the fact that the learned counsel for the petitioner, they had stated what about the grievance redressal officer that we are appointing. They can be biased or there can be a bias that they have. But Your Lordship, it is to be noted that the entire process is going to be transparent. Merely because there is a fear of biasness, this is no ground that you did not approach the grievance.
As your grievance redressal mechanism being validated by any court?
Your Lordship, it is validated by the DPDPA and the IT rules. So, we need to set it up according to the statute itself.
So, those legislations say that a grievance redressal mechanism must be set up and then that you are required to put it in place. has the actual performance of your grievance redressal mechanism been validated by any court, whether Indian or foreign, in any judgment?
Your Lordship, not particularly.
Then, all right. So then we'll reserve judgment, I think.
Okay.
Much
Uh,
obliged, Your Lordship.
We are asking all of the people I need to discuss with my learned colleague. It was well done, guys. It was good job on your part. And now I would ask court reader and just let me and my learned colleague to be there. All of you can please log out.
Sashi,
Grateful, Your Lordship.
I think there's just one person I see, team code 13.
Speaking to. He's stuck, I guess. His student convener can also please leave the room. I mean, if it is.
sir, before actually, I wanted to get the marks noted down from you. I think I missed out on sending you the score sheet. If I share it with you now, do you think?
Yes. What please WhatsApp us. WhatsApp us or.
It's there in the rules.
Huh.
Okay. We'll quickly wrap up. Okay.
Okay.
So
So basically, the way we have basically attacked the government. No, it is somewhat disadvantageous to them also. But what
team 1 ki team 2?
team 2 basically. They have certain disadvantage sort of a way because okay, I am saying okay, I am more convinced of that first team, the petitioner team basically. The speaker 2 was very well able to answer her.
I think dono teamach na speaker 2 was much better.
Yes, both of them actually. They were able to answer promptly.
They answered well. So speaker 1 in both teams spoke well, okay?
Yes.
But I don't think they answered their queries very well.
No.
And in both cases, especially team 2, speaker 2, he had a lot of materials with him, the GDPR, a lot of materials that he relied on, the personal data protection bill, etc.
Yes.
So basis that, what we can do is we can just give points. Okay. We are not to here judge that which team has won relief.
Yes.
So
what we'll do is where is that sheet they are asking about? Okay, मैं WhatsApp खोल रहे हैं एक मिनट. Let's open it. ठीक है. Okay, let's open the sheet. Discuss this एक बार. So the major
team 1 first. ठीक है.
हाँ जी. एक टीम आगे ओदा कोड सी 26